Moot Court focuses on the appellate court process and provides students with the opportunity to present a simulated oral argument before a panel of volunteer judges. Moot court arguments are evaluated on the application of the law to the facts of the case. Moot Court also provides students with their first opportunity to engage in legal writing and analysis. All briefs prepared by the students are evaluated by a team of volunteer lawyers. By focusing on the application of the Constitution to current issues, students engaged in Moot Court learn critical legal thinking skills as well as legal writing. These are skills students will carry with them for many years to come. Students involved in Moot Court also learn much more about our appellate court process and the application of our Constitution today.
Moot Court introduces a new legal skill for students in the legal simulation world, brief writing. Let's take a quick look at how that will work in the competition as we have it for today. First, you should start with a full discussion of the issues before you even begin the brief writing process. In our case for this first inaugural year, we discussed the Fourth Amendment, the requirement for a warrant for searches versus reasonable searches that do not require a warrant. It's really important both for the brief and also for the oral arguments to come that the students have a really good grounding in where the court has been in order to understand what the case is about and how to advocate for their particular side. The next thing that you might want to start with in beginning the brief writing process is to really look at the table of contents. The table of contents in a legal brief is a very specific set out argument with subtopics underneath each element to help the students to really drive the brief writing process, understanding the different components of an argument, and it's helpful in assigning which particular student on a given team is going to be handling which specific discrete element. The next thing that you need to do in looking at brief writing is to assist students in getting their knowledge that you've imparted to them, both from the legal advisor and from the teacher advisor, onto the page. So, in other words, how would a lawyer say what the students know on a piece of paper, in a brief, in a formal kind of context? This is a nice interface with an English department or an English project. One of the things that has been mentioned is that the Moot Court process can be integrated with an English course or as an English project, as there are substantial components of building effective paragraphs, advocating for a position, and other good English skills which can be used as a reference point or as a topic for an English teacher to teach with. The last piece that you might want to think about in starting the brief writing process and imparting to your students is how you can take that, how would a lawyer say it? How would they get a case and put that knowledge onto a page, and taking it one step further, taking it into an advocate position. So how would you distinguish a case? You know how to write it, you know how to say what the court had said in that particular case. How is it different than your case? Why can we ignore this case or distinguish it? On the other side, why might this case be a really good example of how the court should rule in your particular case at hand? And finally, one thing that you might want to think about in brief writing, there's a lot of technical rules with legal briefs. It's helpful to do a group review. This might be something that technology can help you with. For example, on Google Documents, everyone can be looking at the same document at the same time and making edits in real time. And everyone can see what kind of edits you're doing. So for example, if you're going over the Blue Book format of a case citation, how to do a pinpoint cite, you can explain it once, and then the students can go through the document all together in making those changes. One thing that you may also want to do with your legal brief as you're getting into the end polish steps of writing the brief is to really use it as an oral argument preparation tool. So one of the things that you'll want to do is to challenge every paragraph, every thought. Where might a judge attack this position? Or where might a judge want additional information for that kind of paragraph or that kind of legal assertion? I think that that's a really good caption of brief writing, and we may have some additional materials for you as to how you can really make your brief writing soar with your students.
Oral argument is a chance for students to show the judges how much they really understand their side of the argument. As you will see in just a few minutes, the judges can and will interrupt the students at any time. They are trying to find out if the students really understand and can apply the case law. So as teachers, how do we prepare our students for the type of pressure that they're going to feel during oral argument? I think run-throughs with outside evaluators might be the most helpful thing for our students to prepare. If we can bring in some outside sources, people that the students aren't completely comfortable with, maybe the legal advisors that you use for mock trial, if you have those, they might be able to volunteer to help you with that. Use your legal advisor to grill the students on the case law to make sure that they understand the intricacies and the weaknesses that each side poses for the students and their side of the case. Another piece of advice that I would give is to use the score sheet that's included with the materials that students are given. And with that score sheet, you can have the students prepare a checklist of all the different things that they're going to need to do in order to score points. One way to help students prepare and practice to be logical and persuasive, which is one of the skills that they need to show the judges, is to prepare an outline of the various points that they hope to make in their oral argument. That way they can check off each point as they make it. And if they are interrupted by a judge with a question that they were maybe hoping to address later on in their preparation, they can check that point off now, knowing that they made that point, and then they'll need to find a way to try to gracefully segue back to the other points that they hope to make. Use your legal advisors as much as possible, especially for the case law. They can grill the students, and they, I think, can help help the students understand what their weaknesses are, because the students are going to need to address the weaknesses in their cases because the judges will lead them in that direction and will force them, I think, to deal with the weaknesses of their position. So now we'll watch the petitioner's oral argument. In this case, the petitioner, Charlie Charleston, argues that the police search of his car and the subsequent search of the iPad without a warrant was unconstitutional, and the motion to dismiss should have been granted.
Good morning, Your Honors. My name is Victoria Randall, and I will be representing Charlie Charleston in this case. This case is about Charlie Charleston after a shooting. His iPad was seized after his car was searched, and we have a motion to dismiss the evidence that was found on this iPad. Now, this iPad should not have been searched as it was not relating to the case, and Charlie Charleston himself was locked away in the back of a police cruiser, not causing any harm to the police officers, or there was no possible destruction of evidence.
What would the Supreme Court in Gant have said about the ability of the police to search this car?
In Gant, there were 3 prongs that were established in order to search the car: destruction of evidence, harm to a police officer, and whether the occupant was recently in the car. Now, Charlie Charleston drove back to the scene after he left after the shooting, and he was recently in the car. Therefore, they could have searched the car. However, there was no destruction of evidence possible, and there was no harm to a police officer. Now, whether or not they could have seized and searched the iPad is another point of interest, because the iPad was not relating to this case at all, because this was a shooting, not a hacking or a hit over the head with an iPad. Therefore, the car would have been able to be searched, but there would have been a warrant needed to search the iPad and seize it.
Are there any Ohio cases regarding the search of an iPad?
There are no direct Ohio cases relating to a search of an iPad. However, in State v. Smith, they set the precedent that a cell phone is likened to an iPad, where you need a search warrant in order to search it. And we can relate an iPad back to a laptop because they have the same capabilities, as in order to get on the internet, you need Wi-Fi for both a laptop and an iPad. And they both have basically the same capabilities, as you can send emails, search the internet, you can do apps, you can message, you can play games. Therefore, since an iPad is like a laptop in these ways, you can also liken an iPad to a cell phone, where you need a warrant to search that as well. Therefore, for the reasons previously stated, we ask that you reverse the decision of the lower court because of the failure to suppress the evidence.
Next, you'll hear from the state. In our particular case for this year, this was the majority opinion in the lower court. So these particular students have an uphill battle in that they're going to be defending the lower court decision. Judges may have some more vicious questions for them because they have been given a little bit of a head start in some of their arguments. Basically, in our case, what we're looking at from the Fourth Amendment standpoint is whether or not the police had the ability not only to search the car, but also to seize and search the iPad without a warrant. Let's look at a couple of student examples.
Good morning, Your Honors. I'm Patrick Palumbo. I'm representing the state. We are here today to discuss the motion to suppress. The position of the state on this issue is that the motion was rightfully denied by the lower court because the iPad was legally seized and searched by the police. This was done legally under the Thornton v. U.S. decision, which is cited in Arizona v. Gant. The position of the state is also that even if the iPad were to be excluded as evidence, no harm would be done because Mr. Charleston was convicted of second-degree murder, not first-degree murder. And the evidence on the iPad proved premeditation, which is not an element of second-degree murder.
Counselor, isn't a search warrant always required to search a defendant or his possessions?
That is not necessarily true, Your Honor. Under the Chamel v. California decision, police have the right to conduct warrantless searches for reasons of officer safety or if there is a possibility of imminent destruction of evidence. Also, in the U.S. v. Thornton decision, which is cited in Arizona v. Gant, police have the right to search a recently occupied vehicle if they reasonably believe that evidence related to the crime can be found in the vehicle.
Palumbo, in your brief, you talked about smartphones, and we've heard that from counsel. If a smartphone has Fourth Amendment protection, why doesn't an iPad? How are they different?
Well, an iPad is not exactly the same as a cell phone. A cell phone tends to have more connectivity than an iPad does. For instance, a cell phone is connected to a cellular network, whereas iPads are not. Cellular network information can be used to track movements and things of that nature, and that can't be done with information from an iPad. Also, an iPad tends to be used more like a computer memo book, which in United States v. Davis, police have the right to search incident to arrest without a warrant. For these reasons, we ask you to uphold the lower court's decision and deny the motion to suppress. Thank you.
Once both the state and the defendant have had the opportunity to present their arguments and answer some questions for the judges, there is the opportunity for one side to provide a rebuttal. This is just a few minutes, and it can be a segment of time when the judges continue to ask you questions. Because it is the last opportunity to speak before the judges, it's very important and has the ability to be a game changer. Very similar to bonus minutes in soccer, you never know when this time is going to run out on you. So the first few moments of the rebuttal time is your ability to really drive home the critical elements of your particular case's arguments and then respond to some last-minute questions that will come from the judges. For this next simulation, let's take a look at the other issue from this last year's competition, which is an issue of statutory interpretation.
Good morning, Your Honors. My name is Jacob Oren, and I am representing the state with accordance to the issue of the pretrial conference with the statute. The state holds that the motion to dismiss was properly denied as for the Ohio legislator intended that the statute be different from that of the Florida statute. This was intended to make the term of prosecution more broad.
What evidence, counsel, is there that the Ohio legislature intended a defendant to go through the entire trial process before being granted immunity?
The proof is that the Ohio statute of the stand your ground statute was taken directly from the Florida statute, word for word, except for the fact that the very last sentence of the statute, of the Florida statute, gives a definition for immunity of prosecution. The Ohio statute does not. So therefore, we conclude that the Ohio legislator intended for a difference in there because they wanted it to be more broad than that of the Florida statute. For this reason, the state concludes that the motion to dismiss was properly denied. Thank you.
OCLRE provides excellent professional development resources for teachers. The materials that they produce are easy for teachers to use, and really everything that you need to prepare for their various programs are included. If you need any additional materials about Moot Court or any of the other fantastic programs sponsored by OCLRE are available on their website at www.oclre.org.